Hello and welcome to the Rutgers Forum. I'm Marisa Pearson. You've been shopping around for months and finally, well, you think you found the house of your dreams and you're ready to take the plunge. Or perhaps you're the seller of that dream house and you've just received your first offer. Well, what do you do next? It's probably no surprise to you that buying or selling a house isn't exactly a piece of cake. In fact, real estate law is a complex collection of do's and don'ts. And if you're not well enough informed, that dream house could wind up becoming a nightmare. Well, on this third of our special Rutgers Forum legal series, New Jersey, the Law and You, we'll wade through the various steps involved in buying and selling real estate with my guest, Lee Roth. Lee is a real estate attorney from Flemington in Hunterdon County, and Bob Frisch. Bob is a real estate attorney from North Brunswick area. Gentlemen, welcome to the Rutgers Forum on this legal series. Real estate law practice, Lee, has changed somewhat in New Jersey over the past maybe 10 or 20 years. What are some of the significant ways that it's changed?
It's become considerably more complicated. We used to think of a typical real estate file when you finished as being a quarter to a half-inch thick, and today it's an inch and a half or 2 inches or more. Because of the considerable number of documents that are involved and all of the other related complications. There are other things that have changed. For example, real estate brokers now write the contracts, and we end up reviewing a document that's already prepared rather than writing the original document. There are many other stages in the transaction. For example, now people are entitled to have their own lawyer handle the closing, and they're not required to use the bank's lawyer when they borrow money from a bank as part of the transaction. These are all some of the changes. Bob,
one of the changes that comes to my mind is also there's a great deal of more of condominiums and co-ops and these type of properties that people are buying and selling. And the contracts, I imagine, for these are a little bit different than contracts for just a good old-fashioned sale of a traditional home.
Well, they are. There are different concerns for condominiums than in a single-family home. And so when you get into the contract, there are different things that the attorney who represents the buyer and the seller are concerned with than with a single-family home. There are a lot of things that are similar. A lot of the contract concerns of price, of course, and contingencies on mortgage and the condition of the house and the things that are involved with are the same for a single family as well as a condominium. But there are differences, and you have to be aware of those.
Yeah. Well, let's get back to our traditional home for just a minute. Let's say that John and Jane Doe have found that house of dreams, as I mentioned in the opening, and they're kind of ready to make this offer. What kind of guidelines do you suggest when they sit down and they draw up their offer? First of all, should they sit down with their attorney to make the initial offer, the initial first step in negotiating?
They often don't, but I know as an attorney I welcome meeting with the people who are going to be my clients before they get to the contract stage. It gives me an opportunity to outline for them some of the things they should look for and negotiate for in the contract. For example, if they have fully discussed questions like the condition of the property, the financing, the handling of the deposit, the timing of the closing and occupancy, and any limitations or restrictions on use or special needs they have. These items can be taken care of in the contract itself as it's initially drawn, and it doesn't become something where our participation seems disruptive when we bring these questions up after it's initially signed.
A deposit is usually made after, kind of like along with the offer as a sort of a sign of good faith. Is that correct, Bob?
There are usually two parts of the deposit. One is what you mentioned as the good faith deposit, which can be only $100 or maybe $200, and that kind of sets the tone. And normally the contract provides that there will be an additional amount of deposit due within, say, 10 days after the contract is signed by all the parties. The usual deposit that we talk about is approximately 10%.
10%.
But that is not legal. It's a practice. It's easy to compute, and it's a sufficient amount of money that the buyer would not back away from and just forget about it without just walk away from a deal. So we talk about 10%, although $100 or even $1 is sufficient to bind a contract.
So that's really, is that really between the buyer and seller so far as how much money is going to be put down?
It's fully negotiable.
Yeah.
The buyer wants to put down as little as he can, and the seller wants to get as
Sure.
much put down as he can, so that's part of that tension in the negotiating process. Today, with the market somewhat tight and people not having a great deal of cash, they may need to get the money out of the sale of an existing home in order to buy the new one. And they may not have 10% of a house if they're stepping up in value. So again, it's fully negotiable, but the process of qualifying a buyer, something that a real estate broker is supposed to do, or if a broker's not involved, that a lawyer would try to do, is to find out if this person has the resources and financial ability to proceed with the transaction. And that, the deposit is one indication or one symbol of that ability.
For example, if a buyer is looking at a $300,000 house, it should be made clear or the broker should make it clear to the buyer and to the seller both, I suppose, that this person can indeed afford a $300,000 house, and they have the resources, the down payment, they'd be able to secure the type of mortgage to finance a $280,000 or $250,000 mortgage.
Yes, and there are a lot of reasons for that. If you're selling your $300,000 house, you don't want to take it off the market for 30, 60, or 90 days while a buyer tries to find financing if there's really no prospect for their getting that financing. So that's why you would want to have someone inquire into those prospects.
Just to get to brokers for a moment, I know you've done some broking yourself, Lee. Do buyers have to are sort of under the impression often when they go to see a broker that the broker is, quote, finding them the house, but the broker is actually working for the seller? Is that closer to the truth?
That's in almost every case totally true. And yet a poll that was taken shows that 72% of buyers think the real estate broker they're working with is their agent or working for them. And we often find them referring to my broker,
my agent.
And they really are not. The house is listed usually with a real estate broker. They put the listing into multiple listing, and that invites all other brokers to be sub-agents to them working for the seller and completing that sale. So they are technically working for the seller of the property.
We finally get to the contract stage. Let's say that buyer and seller have finally agreed on a price. They've negotiated a little bit. How critical is this contract for both buyers and sellers? There are many, many different parts, many contingencies that should be put into a real estate contract.
Well, the contract is going to set the tone for what happens throughout the whole matter, from the time of signing to the closing. And so it's very important that all the terms and conditions of the transaction are included in the contract to begin with. We talked earlier about the problems that come up at the last minute, and one of them was the proverbial question of why, when the buyer makes their inspection before the closing, they find that the chandelier is no longer there. And the seller says, well, it was never supposed to be there because my grandmother gave me that, and it's historic and it's worth a lot of money and it goes with us. Well, if that's included in the contract to begin with, that problem is resolved. The same thing with the contingencies for mortgage and for closing date. These things should all be worked out so that everybody knows in the beginning where they stand, and at some point both parties may have to make a final decision, which may mean some problems for them. But if you do those things in the beginning, those will be taken care of, and they won't come up as a surprise to anyone. There are things that are unavoidable, problems of financing and things of that type, but we try to cover those things that we can cover and that we know may show, so that we all know where we stand in the beginning, and that minimizes at least the problems that can come up.
So the important thing is to really take care of all this detail work, which may seem even insignificant, because that's the type of thing that's going to delay a closing or maybe even end up ruining a deal in the end.
It can, and one of the things we try to do is to anticipate these problems. Our job is easier if the parties are well educated to the process. That's why we like to meet with them earlier. And our job is also easier if they're working with a particularly good and knowledgeable broker who's willing to face these issues and deal with them early in the transaction. But we'll usually, as most lawyers, will work with a checklist so that we try to cover all of these issues as we review the contract. And we will cancel a contract as we're entitled to during a 3 business day review period after it's signed in New Jersey if after conferring with our clients they determine that that contract is written, is not in their best interest, or has not covered all of the things that should be covered. And in that cancellation process, we'll usually indicate that our client is willing to proceed if the other party and their attorney will make certain specified adjustments in that contract.
So we do have it's a 3-day grace period once the contract is signed before it becomes legally binding, and there's no pulling out after that. We do have
Well,
3 days.
what it is it's a review period. The attorneys for both parties have that time to review the contract, which incidentally can be extended. It doesn't have to be just 3 days, but the contract forms that the brokers use specify 3 days. That can be extended, but we have that time, meaning the lawyers, to review the contracts. We normally confer with the other attorney and with the parties and to see if the contracts are satisfactory or if the changes that we feel are necessary can be made without there being problems. And if there are problems, as Lee says, each of the attorneys have the right on behalf of their clients to cancel the contract, either as a final act or as a basis of renegotiating the contract if that's what is necessary.
So far as the condition of the property, is the seller legally bound to note or to let the buyer know exactly what is wrong with the property? Is the seller required to tell the buyer only the major problems, for example, that the property will need a new roof, the home will need a new roof, or that perhaps there are termites? In other words, is there something like a lemon law for homes?
There are some limitations. For instance, there's a law that provides if you've had a radon test, then you must disclose that before the signing of the contract to a party who's proposing to buy the house. But otherwise, you're not obligated to disclose these defects. It's my suggestion to sellers to disclose any and everything because it protects them from later claims that they had concealed defects that a party buying could not readily see, and therefore avoids the possibility that there will be a challenge to the contract in an effort to cancel it or get out of it because of concealment of defects or other reasons. But generally, contracts will say that the property is sold as is and that it is up to the buyer to perform inspections. And we'll usually see or put in a contract a contingency allowing a buyer to hire an independent organization that will inspect the property and report to that buyer as to the physical condition of the property.
This would be an engineering report, whatever, that would cover everything from termites to the leaky roof to plumbing problems or anything else?
Yes, particularly the systems that perhaps you or I as a layman might not see ourselves. Judging the condition of a furnace, the plumbing system, the wiring and the nature of the wiring. Out in my area, which is a little more rural, we don't have public sewer systems, so the condition of the septic system, the condition of the well. These are things best inspected by a professional who's either a very experienced builder, building inspector, engineer. There are a variety of people who offer these services, and I suggest that people avail themselves of those services.
Before we continue our discussion on buying and selling real estate in New Jersey, I want to reintroduce our topic and guest, which of course is buying and selling a home in New Jersey. Our guest for this fourth segment in our Rutgers Law Series is Lee Roth, who's a real estate attorney from Flemington and Hunterdon County, and Bob Frisch, who's a real estate attorney from North Brunswick. Bob, what exactly is the seller's responsibility so far as the condition of the property, so far as making any repairs to the home before it is sold? I'm thinking maybe in terms of state regulations. For example, if there's a septic system that needs to be repaired, is it the seller's responsibility to take care of that before they put the property up for sale?
Well, there are some things that the seller does have to take care of, and there are times when, under some types of mortgages, the banks require that certain things be done. Again, these things can be negotiated, and as Lee points out, most contracts will say that the property is being taken as is, so that if repairs have to be made, it would be the responsibility of the seller, of the buyer normally, unless there was an agreement between the buyer and the seller to do these things. Now, we have gotten away from caveat emptor as far as the contract to buy a house, but not entirely. As Lee said, we have substituted some of those things with the inspections for radon, home inspection, and that sort of thing. And I think where we are is that the seller has to avoid or is responsible for things that are known but may not be easily found out by the buyer, such as we talked about that one case involving the roaches that were hidden, which kind of set the tone, I think. Said the buyers refused to allow, the sellers refused to allow buyers to see the house during the day. Went through the normal routine, mortgage and so forth. The house closing took place, and the buyers went to see the house after the closing, which was at night, turned on the lights, and the walls were covered with roaches.
So they had never visited the house at night.
And they started a suit, and there was a finding in favor of the buyers, because the court held that the sellers knew about this and failed to disclose it. And I think that's probably one of the big problems. Now, the ordinary thing of the broken piece on the stairway or the paint on the garage door, those are things that will be found easily by looking at them, or that the inspector will find.
Yeah. Yeah. If something is found wrong, for example, the house will need to be fixed, there's a radon problem, and the house will need to be ventilated or whatever, or there's a termite problem or some kind of major repair. Is that also negotiable in this whole contract? In other words, the seller might agree to knock off some dollar amount from the price, or the buyer might agree to pay for part of it, or what kind of deals are usually struck in these cases?
It is negotiable. The contract, again, will control who's going to do that. But one must be careful because, for example, in many municipalities, we now have a reoccupancy law. So when you sell your house, you have to get a new occupancy permit showing it's fit to occupy. And the municipal inspectors come out and inspect it, and they will say you need to fix a variety of things that they see. A common example I'm running into is your basement stairway is, in many houses, completely open on one side. And it must be enclosed on that side to the point where you can't put a 6-inch projectile through the railing. And that can cost $100 or $200 to fix. So the question is, how is the contract written? And you come back to that issue. If the contract says that the seller must provide a certificate of occupancy, and if anything need be done to get it, it will be done at his cost, then the seller will pay that cost. It may also provide a limitation on the amount of cost that he'd be expected to pay, and that he would have an opportunity to cancel the contract if he chose to. If he has that option, then the parties negotiate as to who's to make payment of these repairs. There also are some modes of financing where the lenders will provide that the buyer and borrower may not fix the items that need to be fixed as part of the inspection process. So both buyer and seller have to be aware of the nature of the financing provided for in the contract. With a conventional loan, it's not a problem, but there may be various kinds of government-backed loans or Veterans Administration loans that have limitations as to what costs the buyer is allowed to pay. And then the seller might be in a position of having to pick up those costs to complete the transaction. Again, an item that should be discussed and negotiated early in the transaction.
Sure. A lot of people buying homes today are doing so with the idea that perhaps they will run a business from their home, whether it's accounting business, for example, or some sort of home occupation. What do you, and I guess your broker, need to know before you start looking for such a home? Are you going to run into zoning problems with this type of a home occupation plan?
You can, and the buyer should let this be known early on, especially to the broker, because by and large, in this time, the brokers see the buyers sooner than the attorney does. And they should know, first, because they don't want to, the brokers don't want to waste their time, nor the buyer's time, by showing them a home in a residential area where you cannot have any kind of a business. Secondly, you don't want to sell them a home and find out that they cannot have it and have it, all their plans completely nullified by that sort of thing. So that's a very important thing to, you know, if you think about it later, that's one thing, but when you start into it, the buyer should know and should inform the broker and the attorney, and then the broker should find out the zoning of the area and know where a business can be conducted in a home and where they can't. And the zoning laws are pretty strict about that today and pretty limiting. So you want to start off with that. Again, it gets to the questions also in the contract that sometimes it's a question whether or not a business can be conducted, and so we will write a contingency in the contract that says that it's subject to the buyer securing approval to do whatever he wants to do in that area, and if that cannot be secured within a certain period of time, then the buyer can withdraw from the contract, and that's important.
So far as financing, and of course this is something that a lot of people run into problems, especially first-time buyers. A lot of times they have problem coming up with a down payment. What kind of limitations are sometimes faced by first-time buyers, Lee? And what other common mortgage problems do buyers encounter?
Well, a first-time buyer has one advantage. He usually doesn't have a house that he has to sell in order to get into the transaction, which has given us problems in many transactions these days. The mortgage condition in most contracts will appear to be met, but the actual commitment for a mortgage will have something in it that says the owner or the buyer of this house has to have sold his existing house at a given amount of money. And the courts have interpreted that as not a firm commitment and not meeting the terms of most contracts. With a first-time home buyer, the usual problem is that they have not managed to accrue enough money for a down payment. And in today's market, the lenders are getting very strict in terms of the values and the ratios of income that you have to the mortgage you can carry and the down payment that you can place on the property. And you may have to buy mortgage insurance in that kind of a situation. Now, that's not life insurance that pays off the mortgage if you die.
If you die, it's a different thing.
That's an insurance that pays the amount of the first amount of the mortgage that's owed in the event of a default. And in that kind of a situation, there's not only the mortgage payment to pay, but there's a premium on that insurance that has to be paid, which increases the monthly payments and costs. So that has to be looked at. Many of the special first-time buyer programs also are some of these programs that require that the house be in a given condition and that the buyer not be expected to contribute to the cost of repairs to put the house in that condition. And because many of these people are buying lower-priced homes, they're lower priced partly because they're not in as good a condition. So you've got this circular thing where the house has to be in good condition, but it would be priced higher if it was. So you do run into a situation where you have to take care in the contract to provide who is going to pay these costs.
Sure. Bob, do first home buyers also encounter some benefits that are perhaps not available to other people? Some reduced interest loans might be available to them?
There are a number of programs.
On the bright side.
Right, that's right. There are a number of programs, one in particular that the state has for first-time buyers, which provides low interest rates that are, I think it's 8.5 or 8.75, and that's a very nice interest rate now, and that's a conventional type. So it's very helpful to them And if they can qualify for it, it's the kind of thing that anyone would like to go, especially a first home buyer.
Sure. Real quickly, we only have about a minute left. What's the most common mistake or maybe oversight or that a buyer and seller might traditionally make when going through the real estate transaction?
I can think of three. One is not getting advice and learning about what they're into soon enough. But if we get past that, the thing that we most often end up changing in a contract is the provision for the deposit, how it's to be held, whether it does or doesn't earn interest. The second thing is probably the question of use of the property. Things like, can you have pets, or are there restrictions against those animals? And the third thing probably is the timing of the occupancy in the closing.
Mm-hmm. Lee, thank you so much. Lee Roth, Bob Frisch, I want to thank you for joining me on this week's edition of the Rutgers Forum. I'm Marisa Pearson. Thanks very much, and I'll see you next time.
Funding for the